Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
All right, we got Michael Hill out of Cleveland, Ohio with us today. And Michael's been on once before, and we didn't really know each other then. But since that time, Michael and I've got to know each other a lot because we've been to a few conferences together, National Trial Lawyers, AAJ in Austin. I think one more, but I don't remember. But Andy's also coming. Well, he also came out with his associate Matt and did the boot camp out here in Vegas. So now we have a much deeper understanding of who each other is, and which is a good thing because now I can attest to it. Not only a great trial lawyer, but pretty decent guy too. But we'll go with that. We'll just leave it at that. We want to go. But anyways, now we're here today to talk about some other things, and that is much more educationally focused because Michael's doing a 2-day master class June 5th and 6th in Huntington Beach, California on elder abuse from intake to getting the verdict. But he's also going to be hosting 4 webinars in the month of May that all have to do with elder abuse. And eventually in September, we're going to be doing a different type of elder abuse case framing master class for up to 8 students in Las Vegas. So that's the stuff we're going to be covering today. And so we'll get right at it, Michael. So
very cool.
Let me ask you, elder abuse. How did you decide to make elder abuse the sole focus? Because you're the only lawyer in the country that I know who makes elder abuse their sole focus. How did you get to that point?
Yeah, so it was probably, when I started my career, I was doing a lot of med mail and a lot of civil rights cases, jail civil rights cases, mostly was a form of med mail. And I'd have probably, 2, 3, 4 elder abuse cases per year. And I was at a very reputable firm. It was a great firm, but they were low value cases. And we just thought of them as low value cases. I mean, these are old, sick, and dying people. And, so we would settle these out. And they were kind of similar to low value car accident cases. They were the cases that, kept the lights on, basically, cash flow. And a great result in one of those cases might be a $500,000 settlement. That was a great result back then. And then I ended up trying one of these cases that everybody pushed me in the firm to settle for $250,000. It's not worth more than that. And it was a $4.4 million verdict. And I thought, you know what, there's something here, right? Lawyers may not value these cases, but jurors do. And that was, I think, October of 2016. By February of 2017, I had started my law firm where I did exclusively elder abuse. And what I realized is that folks were doing these wrong and went with it.
All right. Well, like every practice area, the most important thing always starts with case selection. So I'm going to talk to you about case selection in 2 forms. One form is from the general public, but also case selection from other lawyers. When other lawyers ask you to help with the case, what are the variables you're looking at to decide, okay, this is a case I'm going to sink my teeth in, or this is a case I'm going to pass on? But let's talk first from the intake that most of us have from John Q. Public. What are you looking for?
Yeah, so I call it the 30-second rule, or kind of the elevator pitch rule. If I'm not hooked within 30 seconds, where it's not, that can't happen, reaction, within 30 seconds of telling me the story, it's not a case, in my opinion. It's got to be that simple, where you look at it and go, you literally say to yourself, that can't happen. Now, I don't know what the underlying negligence is necessarily, but that can't happen. And that's my rule of thumb. Okay,
so now to get a little more detailed on the rule of thumb, flesh it out a little bit more for us regular folks that are making these decisions.
Let me give you something. Yeah, let me give you an example. So you have a case, let's say, where somebody, is on a certain diet. They got to be pureed or liquid diet, right? They have to, because everybody knows that's the safest thing for them. There's an order for that. And then they choke to death, right? Well, they couldn't have choked on anything if they were getting the diet that they needed to. That's a case, right? I don't need to tell anybody else that. I just tell them that on the street and they go, wait, that shouldn't happen. That's not a thing that should happen. Somebody who, for example, case I have right now, they wander out of the facility. They've got dementia. They don't know where the hell they're supposed to be, right? They're there at an assisted living facility for dementia. and they're found the next morning. Nobody can account for them, and they're frozen to death in the parking lot. Well, that's a case, right? It doesn't matter. That right there is enough of a hook. When you've got cases where there are multiple layers, you have to if this, and if this, and if this, and I see that a lot. To me, that's not a case. It does not have that hook.
So it sounds like what you're saying is like, you need an expert to explain to somebody why it's a case. You don't have a case, at least in your opinion,
That's
one that you're
exactly
interested
right.
in.
Yeah, and I think it's one that juries are going to be interested in.
That's where it's right.
Right? And we know that because you're testing these at focus groups. This is happening over and over and over again, and you're testing these cases. I don't want to get too far off track, but what I learn is that jurors go with that gut reaction. It's that story, that initial hook, and they're going to stick with it because they're going to buy into the story, not the experts, not necessarily the facts. It's the story.
Right. And let's take a look. It reminds me of when I did this sizzle reel for it was going to be a reality show out of Detroit, the criminal defense lawyers. And I remember saying, it's not the facts, it's the story. Just it reminded me of that. I digress for a moment, but let's talk about intake. Like when other lawyers come to you and they have cases, and I assume you get a lot more pitches than you are that cases you're interested in. So what is it, when you look at somebody else's case who's interested in having you consult or co-counsel or refer to you, what are you looking for?
So one, I'm still looking for that hook. Okay, I don't care what depositions they took. I don't care how great those were. It's the story, right? You can be a great lawyer. If you don't have a great story, you're not going anywhere in front of a jury. Two, I want to look at, who they deposed, right? Did they depose the right people? A lot of time that's not the case, and we'll get to that. The other thing I want to know is the facility, right? We want to know what's this facility's history, right? This nursing home. Is it a good nursing home with a one-off issue? Or is it something that we look at, and there's tons of public data that takes you about 5 minutes to figure out, is this a place with systemic failures across the board? Is this place where you're seeing repetitive? The reason that's so important is, one, if we have that, we know that there is a huge systems case, and we know there's likely to be former employees who are going to come in and testify to help you. You just got to find them. But when you get a facility that's a 5-star facility, and I mean 5-star Medicare rating, you get one of these really good facilities, great reputation, it's probably a one-off issue. And when you have one-off issues, one nurse making a mistake, it's not as powerful. I'm not saying there isn't a case there, but the systemic abuse is not there.
Got it. As far as, and we're going to talk about systemic, failures in a moment, but you also mentioned focus groups, and that's what I want to talk to you about next, is what are you doing with these focus groups to help prepare these elder abuse cases? And and we're going to be doing some focus groups on some upcoming cases too. I want you to mention that too, as far as Huntington Beach goes.
Yeah, so I look at focus groups really in 2 phases. There's the pre-suit focus group, and then there's the during getting close to trial, mock trial focus group. And those are 2 very different things in my mind. Actually, as part of the screening process, I often do focus groups on the story, right? What does the jury think of the story? I don't need records at that point, right? The jury's going to put it together. The reason that I do that so early is, one, you're finding out from that story, what are the warts in your case, right? What is the story that potential jurors are telling themselves? Start building that early on, right? Because you're going to be in jury selection if you're a trial lawyer. 2, they're going to identify for you the standard of care violations, right? And the way I look at standard of care violations is experts don't prove the standard of care, the jurors do, right? The jurors are deciding what the standard of care is ultimately. Your expert's job is to give just a basis for that rule or standard of care violations. So learning that early on from the jurors focus group frames the case for me, or helps me frame the case. And I'll give you just some key examples. I had a case that was a pressure injury case, which is a bed sore. I mean, it was massive on this person's back. It was down to his spine. Now, he recently had a fall from a ladder at work and broke his neck. Okay, so very bad going into it. But all throughout the records, it was he refused to be turned and repositioned, refused to be turned and repositioned. And I look at that case going, man, this is tough. What are the nurse supposed to do? And so the jury's looking at this though, and they go, well, they must not have educated him, right? And we're finding out, what do you mean by that? And they go, well, did they show him pictures of what a pressure injury looks like, a bed sore? Did they say that he would get, the systemic infection and die? Did they do this? Did they do this as part of the education? They've got to educate him. They got to educate him. They got to educate him. Well, that's not an avenue that I was thinking about, right? But it became incredibly powerful in the case that when you're in deposition, you've got this great rule. And so you establish with the nursing home employees, part of your job is to educate the patient on why they need to be turned and repositioned, right? Yeah, absolutely. That's my job. And then you start going through all the things they didn't do that the focus group wants to see, that they think hits the objectives there. So early on in the case, I'm in focus groups to find out what is that thing that the jurors just can't get over. What's that thing that they see unprompted?
All right. And so that's one focus group, to figure out that thing. Now you talked about a second focus group where you're doing something a little bit different, closer to trial.
Yeah. So as we get closer to trial, and I say closer to trial, I mean, 4 months, 5 months, 6 months, right? That's what I consider getting closer to trial. Now it becomes much more similar to a mock trial. And what I do is, number one, I have to start doing jury selection early on, right? Because I think that's the most important part of the case. I think a lot of lawyers would agree with that. But your jury selection, it's going to be different case to case. You're going to have different, quote unquote, words that you have, things that the jury is going to be thinking about, right? The jury is going to tell themselves a story. It might not be your story, right? It might be the story of, why wasn't the patient doing this? Why wasn't the family doing this? So you're working on that jury selection to hone down exactly what you want. Perhaps what are the visuals that you need for the jury selection? What are the questionnaires that you're going to need to have for the jurors ahead of time? So you're working through all of that. And the other part of it, that's the jury selection part, which I think people don't do enough practicing of their jury selection. They might do enough thinking about it, but they're not doing enough practicing of their jury selection in front of an audience.
So hold on. When you say practicing your jury selection, do you mean getting a focus group together and, you're not the guy that's the MC. You come in cold and you like, folks, good morning. My name is Michael Hill and I'm representing the plaintiff, and this is voir dire. And then going through an hour of voir dire, which is what, let's say, so that way it's, or whatever amount of time you typically get in the jurisdictions you practice. So you have you're doing actually like a dry run of the actual voir dire and not just thinking about it.
Exactly, because voir dire, it is a form of conversation, and you don't necessarily know how that conversation is going to go. You may expect one thing, but it goes a different route and a different route and a different route. The more you practice doing that cold in front of a group of people, number one, you're going to find out where that goes down the line. You've already interacted with people and seen where that happens. The other thing is, it's just like any practice, right? What do they say? That repetition is the mother of success. You have to be doing it. And that's your first impression in front of the jury. That's the most important part of the case. And if you're not up there doing it, you're not going to be comfortable doing it. And I hear a lot of people say, be authentic, be authentic, be authentic. I think what they actually mean is be comfortable. Be comfortable up there, which is a very different thing than being authentic, because you can be authentically unlikable.
Nervous, terrified.
Yeah.
I'm authentic. I was being myself. I myself as a scared, shaking, insecure trial lawyer that's unpracticed. That's authentic.
Exactly.
But it's not the most effective. I couldn't agree with you more. It's like, I hear all this stuff, be authentic, be authentic. I'm like, that's horseshit. Be great. Train. Don't,
right.
I mean, if you're all nervous and shaking up there, guess what? You look insecure. You look uncertain. Nobody files insecurity, uncertainty. People file confidence, straight, even if their message is completely nonsense and a complete lie. I mean,
No, it's true. That's why confidence men, right? That's where it comes from, right?
Confidence men, got an example of that on a national stage with a trial starting.
I'm thinking the same thing, right?
But not to be, we don't want to mix politics here with anything, so we're not going to tap it directly. But it's crazy. Tell.
Well, and let me just say, I think that people just pull out their last dusty jury selection from their last trial, and they get up there and do it. And that's your first impression. That's the first impression you're going to make in front of that jury. And everything comes, just like anything else, the more you practice, the more it slows down. So if you're up there and you get an angry juror or a person who hates lawsuits, who says money damages is never going to amount to anything, you've gone through that enough times that now it's second nature. You're comfortable responding to that, not that, what if the judge instructs you that you have to follow the law? Well, that doesn't get us anywhere, right? You're comfortable up there doing it.
Right. And okay, now I got this response. Do I take and follow up on this? Do I spread it to other jurors before I follow up? Do I go to start to, ask questions for cause? These are 3 different options, and each one may be appropriate in each case, but you won't know it without the practicing of it. And the more practice you get, the more calm you are, because the more predictable, because human language is a pattern. And the more that we can see the patterns, the more that it all makes sense. Because there's a saying that the trained mind sees patterns where the untrained mind only sees randomness. And that's the huge benefits. And like to do this mock focus group, but you also got to record it and play it back and hopefully have somebody that's in your circle, your sphere, that can give you feedback on it other than yourself. If you got to a decent level, you can self-coach. But other than that, you need output from other people to look at the work you're doing, because you're doing the best you can. And you only know what you know. So.
Absolutely. And for example, just over the weekend, I've got my associates here getting ready for trial. You know the trial because you've helped on it. Getting ready for trial and doing their opening statement, and we're recording it and breaking it down. And it's brutal at times. It's hard to watch yourself sometimes, but you're getting better.
Right.
And that's what you have to remember.
And that same horrible performance that you just did, you're torturing your colleagues, not some poor jury with it. And your colleagues are going to give you feedback that you get better. The jury's going to give you feedback. By the time you get it, it's too late to get better. And it's like, and they're never going to tell you, you know what, you suck, you didn't connect, because they don't even know how to. They're just like, I didn't buy your story. That's what they're saying.
Yeah.
I wanted to help you, but I couldn't because you didn't have the evidence. That kind of crap.
Yeah. And when I do the opening statement, I've got the MC there. I do the opening statement. I leave, and it's brutal feedback. They've got questionnaires. It gets less brutal the more you do it, obviously. But there's things where you think it's crystal clear, right? And you're going to stand up in front of a jury and show this slide or say this thing, and they go, I didn't understand any of that, and then you break it down. Well, what would you understand? How would it be better? Oh, how about like this? Well, that's great. I'm glad I know that 4 months ahead of time.
Okay. And as far as these focus groups, we're going to be running focus groups May 30th and 31st down in Orange County at Jonathan Michael's courtroom on, a couple cases that are elder abuse cases are going to trial. So.
Yeah. And that's really, I think, one of the unique things about this masterclass we're doing is we're doing it during the week. I start trial on Monday. I'm flying back to hop into trial. So a lot of this masterclass is going to be built around this trial that's happening. So this isn't some theoretical thing, right? This is real world practice stuff where we're looking at, potentially an 8-figure verdict or a 0 verdict, depending how it goes, right? So we're in the context of something that's real and powerful, and we're going to see that come to fruition.
Right. But the focus groups before the main conference and during the main conference itself. But I was throwing it out there in case people are local, they want to come by Jonathan Michael's courtroom, kind of be a spectator for the focus group, or actually, have a couple of jurors, a couple of lawyers sit in, I think, on these type of focus groups to ask those tough questions, because sometimes when you're paying people, they get a little kumbaya-ish, and, you think you're out at the ranch where everybody loves each other instead of the real world where jurors often get aggressive. Right.
And especially the more likable you are, right? The more they're going to not want to tell you bad things, which is why I get the hell out of the room, right? Whenever they're saying anything. Now it's on video, they're being recorded, but they think that I'm not going to see that. They think that someone is just going to report back to me anonymously. So I think you have to do it that way.
Right. But also to have a couple plants in these focus juror groups that will spur the rest of the juries to say the harsh stuff, like that's a crazy amount of money, or this money's not going to, how's that money going to help anybody? Or, you sound like a greedy lawyer to me. But all those things that could throw us back a bit that we get in real jury selections, but being comfortable handling those kinds of ribs or jabs or attacks or whatever you want to call them, gifts, however you want to frame it, so that, boom, we're ready to go in the real world. So That's
Yeah, and you get comfortable saying, that's a great point. Blah, 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 right? You're very comfortable responding to that as opposed to, uh-oh, flat-footed.
right. Exactly. So we got focus groups. So once we get our focus groups, we got the case dialed in with the initial focus groups. We work on our voir dire and opening statement skills later on, with a little bit different type of focus group. But from there, we're going to be talking about, how do we find about systemic failures as opposed to one-offs. So talk about that a little bit.
Yeah, so I think when you're looking at a nursing home case, it's similar to trucking and some of these other areas of work that a lot of people do that get large verdicts. It's not about the individual caregivers. And I've seen repeatedly cases that come to me, cases I've observed, cases I'm consulting on, where they make it about the caregiver, right? This one caregiver was a bad employee or a bad actor. And oftentimes that's not the case. And even if it is the case, it's because of some systemic failure that happened. I've got a couple of cases, but one of them right now, it's a choking death case. And it's horrible. It's on video. It's absolutely appalling. He's clearly gagging. He's clearly choking. And an aide walks in and hands him a bucket as if he's going to puke in it and walks out of the room. And you watch this guy slowly die on camera. It's horrific. But so you want to say, well, who's this aide? Who's this piece of garbage person who did this and walked out? But in reality, she's a temp. She knows nothing about this guy. She comes in that day for the first time, knows nothing about him, isn't introduced to him, knows nothing about anything, and is never trained. She has no qualifications to be there. And as you start peeling back that onion, you realize that's not just with this guy, that's all of these people. And it's a pattern every day. So that gets us back to the parent company. It takes us from this nursing home, which is a single corporation. They make these individual corporations that's running at a loss. And it gets us up to the parent companies where we're talking about owning, potentially hundreds of nursing homes and huge amounts of money. And the systemic, one, that's where the money is. But two, from a system standpoint, that's the thing that's going to aggravate the jurors. And it's going to aggravate the jurors, I think, for a very clear reason. And that's that this could happen to anybody, right? It's kind of like Ball and Keenan's tentacles of danger. They start to recognize that this case is bigger than this plaintiff. It's bigger than this case, and it's bigger than any of us. And so they have to do something. They have to do something to change the way this works, or else it's going to happen to somebody else. And until you get through that system's case, you're not motivating the jury. You might motivate the jury for, I don't know, a couple $1 million, but you're not going to motivate them to want to change things. And jurors are smart. They understand that corporations, the only way you change them is with money.
All right. And so the systems failures instead of the one-off failures.
Yeah. And I'll tell you that there's some repeated systems failures. One is that parent company. So the large entity where it all filters down. There's all these companies underneath it, including the nursing home. They are responsible for everything. So they set a budget, for example, for the facility for the year. And they just do that on last year's budget and then try to make it a little bit less the next year so they can profit. And doesn't matter who's in the facility. They set the budget for what they call hours per patient day. It literally is, if we break everything down and we, mix up all the numbers, each patient gets a certain amount of hours per patient day or minutes per patient day from nurses. Well, they're setting that budget. And they're getting lower and lower and lower and lower year after year. So they're responsible for the staffing. They also are responsible for all the policies and procedures. If you ever look at these policies and procedures, they're always stamped with that corporate company. So that corporation knows what's supposed to be happening, but they're intentionally understaffing this facility to siphon the profits. So they know that this can't happen. They know those policies cannot, actually be implemented. And the other thing is they don't train. Right? They may say they train, but they don't. And the way we know they don't train or the reason they don't train, again, a systems failure, is because training is really expensive because you've got to pay people when they're not actually providing care or on the floor. That's really expensive. So what we find out a lot of times is they try to do training while the person is actually working. And we'll have staff members and employees say, well, I got to make a decision. I'm already understaffed. Former employees typically, I'm already understaffed. I don't have enough time to even care for my patients. And you want me to train at the same time. It's not possible. And so all of this is coming down from the corporation. And the result of it is one, your client's basically collateral damage. And I mean that is that it's going to happen to somebody, and it is happening to other people. This just happens to be one example of all this wrongdoing. And the other thing that's very powerful about the systems case is not only is the nurse or aide not a bad actor necessarily, they might be a victim in this as well. And so you've got oftentimes an out-of-state corporation or a very large corporation, not just siphoning profits in a way out of the community that hurts this individual patient or patients, it's also harming the workers in this community, which again motivates the jury to do something. And you're turning the employees into victims here. Again, very powerful because the jury wants to help them too, on balance, because these are members of the community.
All right, just to let everybody know, this June and 5th and 6th masterclass is part of the bigger conference called Trial Lawyers University Huntington Beach, and which is a 4-day conference, Wednesday, Thursday, Friday, and Saturday. But this is the Wednesday, Thursday portions of it. And so just let people know that, I just make sure that was clear. So you talked about systemic failures. Let's talk about depositions, and specifically the 30B6, or in Ohio, the 30B5. Start with that.
So I think it's important to start your depositions. Obviously, you're preparing for depositions long before. You're preparing that from the focus groups. What do they want? But I start depositions with the 30B6 or 30B5, depending on your jurisdiction. I do that oftentimes before even issuing any paper discovery. And the reason for that is when you issue paper discovery, you get all these nonsensical objections, right? Of, blah, 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 blah. And oftentimes the attorney doesn't even understand your instructions. So if you start building out doing a 30B6, what documents are available? How are they tracking this? How easy is it to get it? You're going through, it's just a couple of keystrokes. All the staffing data, who has access to it? It's an Excel spreadsheet. Things like, they'll try to act like the budget is something that's, jointly done between the nursing home and the parent company. You look at the draft budgets, they never change, right? There's never a response. There's never anything. They just go along with it. So tracking logs for the facility in terms of wounds, infections, whatever you're dealing with. You're able to get that without objections because you're asking somebody who's the corporate rep what they have, how easy it is to get it. Now, if you have to go in front of the court to get it, you've got this great testimony locked in about one, how important it is, why it's relevant, and how easy it is to get. So this is very Kaz, right? I got this from Kaz in a lot of ways.
Wait, that's just so we're clear. That's Mark Kazaratsky, who will be teaching 3 hours in Huntington Beach. So go to the website, see exactly what he's teaching, when he's teaching. Go on.
So that's really the document part of it, right? Getting the paper discovery, everything you need. The other part of it is you're able to really build out who are the players here, right? Who's the parent company? Who's the management company? Who are all these different layers, right? Who's the real estate company? And then you start to find kind of this money trail. Now, I said earlier, nursing homes have very little money on hand, right? They run at a loss. But what you start to learn in these depositions are things like the real estate deals. Well, the parent company, a lot of times, owns the real estate company. And the nursing home is running at a loss because it's got such a high lease. It's paying off the entire value of this nursing home building every year or 2 years or 3 years so that they can pocket all this money and have very low taxes. Real estate taxes are quite low, right? That's why people invest in real estate. You also have this other management company siphoning off money. And you've got this siphon, all of it goes back to the parent company. And now you have this trail of money. Again, now you're building out this system case of why things are happening the way they do. And why is it happening? Well, it's to make more money, right? It's kind of like, it's the 3M rule, right? Make more money.
That makes sense now. That's what they're there for, to make more money. Other than the 30B6 deposition, what are the key depositions in these nursing home cases?
So the key depositions, I think, are, the former employees. Now, I would like to sit on the former employees until trial, but that doesn't always happen. So those former employees getting their testimony clear. And to go back to the pre-suit investigation, I try to get the former employees then, before any lawsuit is filed. Because once the lawsuit is filed, any decent attorney is going to go round up everybody and tell them the story, and they're going to walk the corporate line. If you get to these people early, you get the truth. And so getting those people on your side, early on, getting that deposition testimony locked in. And a lot of times I get affidavits from them before their testimony, so it's very easy for them to testify. The other things, of course, are going to be, director of nursing. That's the head nurse at the building. The administrator, which is supposed to be the person in charge of the entire building. In reality, what you'll find out is they're a puppet who at most has about $500 in petty cash, right? They make, I'm not joking, that's standard in the industry, right? They've got $500 of petty cash they can use without getting authorization from the parent company and that's, again, building out this systemic case because you're realizing every decision is being made at the corporate level.
Okay, and to find these ex-employees, how do you go about finding them? Do you do that yourself?
There's a couple of ways. The easiest way is to go through Strategic. Okay, Strategic is a company. Paul Luttrell owns it. He's fantastic. What they do is just get former employees for basically any industry. So contacting them, they'll give you, a list of, depending on how long they've been at the nursing home, 30, 40, 50, 60, 70 potential employees. And then they'll vet them for you, or we vet them in-house, one of the two. And then the other way to do it, there's two other ways to do it that I've found useful. One is a press release. You can put out a press release, and a lot of times journalists or reporters will pick it up, and you start to get traction from people in the community. The other way is Facebook. You can do pretty targeted ads through Facebook. And I guess some people might be shy about it. I'm not, right? I'm a lawyer. I investigate cases. You can have Facebook ads targeted to your community with whatever demographic you want, people between 40 and 80. And you're asking them literally, if you have any information during this time period on these issues, contact us. And people do that. And former employees do that quite often. And building it out in terms of depositions, another, I think, crucial area where lawyers fall down is other residents have family members who experienced something very similar in the nursing home. And so if you have 5, 6, 7 family members of residents at about the same time who can come in and tell a very similar story to yours, which is, we'd use the call light and nobody would show up. Every time I walked in and saw my dad, he was sitting in his own feces, X, Y, and Z. Again, get that in front of a jury. That's relevant, right? That shows that there's this pattern. Again, it's upsetting to the jury because they see it's not about your client. It's about the community and everybody it's affecting. So you have to get former employees, try to get family members of other residents for depositions. You want to do the 30B6 depositions, and without question, the nurses involved, if they still work there, and the director of nursing and the administrator. And there's very specific ways to go about all of those because they're all playing different roles in your case. When you're acting as the director putting this case together, every one of those has a different role. And they need to know their role, and you need to know their role.
Right. Now, I know in these cases you get a lot of, or oftentimes you have a lot of, as you mentioned, the video of the person choking to death, the photos of bed sores. And so this very graphic and compelling video and photographic evidence, how do you go about effectively using those in the trial?
So I think there's a tendency to overdo it because that is your best evidence in the case. So what I've seen a lot of lawyers do is repeatedly show these pictures, repeatedly show these videos, and you see the jury cringing at this, right? It's too much. So what I try to do, number one, I think you have to, in jury selection, let them know that I have to show this video. I have to show these photos. Part of my job is to prove what happened here, prove the damages, whatever it is, and ask them, right, to give you permission to do that. And of course they do. Now they understand. They know it's not about sympathy or grossing them out. You'll say to them, I'm going to try to show these as few times as I can. Then I try to wait to show those to an expert, right? My client's not there. They're out of the room, obviously, and show them to an expert. Or if it's a video, run the whole video through with the expert. The jury only needs to see these once, right? They're going to remember it. They don't need to see it 3, 4, 5 times. It's disturbing to them. And in focus groups and mock trials, what I've learned is they get upset with the lawyer for doing this, because it appears that you're taking advantage of this. You're showing it too much. And in particular, don't ever show it if your client's in the room, please.
Right. Right.
And the other thing, let me say about video. One, and I think this happens in security cases and other cases, getting a preservation letter out immediately on the video is critical, because what often happens is, number one, those videos, they overlap a lot of times with time. They roll over 30 days, 60 days, sometimes shorter than that. So getting that out immediately. The other thing you have to do, though, is get the long stretch of video, right? So when there's a pending lawsuit, or they think there's a lawsuit, preserving evidence may be, hey, I'm going to preserve this 10-minute, situation of a person falling or person choking or whatever. A lot of times it's the video long before that, days before that, if you can get it, that is actually showing the systemic case, right? A lot of times that's showing nobody responding to call lights, or nobody in the hallway for 30 minutes, no nurses. Those kinds of things are powerful. And as lawyers, a lot of times we jump to the punchline, right? But we lose the setup. Those are the things that are proving that this is an example. This is the expected result of all of these being shown on video. And those, I've noticed, are actually a lot of times more powerful to the jury than that terminal dying event.
Mm-hmm. All right. Well, now we've gone through most of the stuff that before we got to trial. So let's talk about trial, and specifically let's start off with jury selection. So how do you go about, the process of selecting the best jury on these types of elder abuse cases?
So I think, number one, you need to get a jury questionnaire if at all possible. If your jurisdiction allows it, most do. Judges, for the most part, like jury questionnaires because you can convince them that jury selection is going to be a lot shorter. It's going to speed things up, and that's what judges always want. Anytime you can tell a judge, hey, it's going to make things go faster, they're usually with you. And those jury questionnaires, I think they address a few things, but there's the general background, of course. I put in there about internet inquiry. So what is your favorite social media sites? I don't ask them directly. What social media are you on? That's intrusive. You can come across as a stalker, but if it's their favorite, Twitter and Facebook, they're using it. Easy to do internet research on them at that point. And then scaled questions. And let me just back up. The reason I think jury questionnaires are powerful is that, number one, they don't know if the judge gave it to them. They don't know which lawyers thought this was important. And it's relatively anonymous, right? They'll answer things sometimes that they'd be uncomfortable answering in front of a group of people. So you get to that early. And I put scaled questions in there. Things like, how strongly do you agree or disagree with, money for someone's death or money for whatever? How do you feel about lawsuits against nursing homes, right? Those are kind of the scaled questions. And then there's kind of the value questions you can put in there, right? Like, who are the three people you admire most? Who are the three people you admire least? And the reason, and there's several more, you want to keep questions pretty short, but the reason you're doing that is what I found is my ideal juror just has two aspects, and that's they have empathy and they have the potential to get angry. And that's it. Those are the only two things. I don't care about demographics. I don't care about religion. I don't care about anything, because if you put the case together right, you've got a common denominator, right? It doesn't matter who you are, where you're from, there's right and wrong, and this was wrong, right? You simplified it to that point. So this is just kind of the litmus test, right? That's getting you an idea of who you want. And if it's who you admire most are my dad, my mom, my grandparents, you're on the right track with this person. If it's who you admire most and it's Kobe Bryant or something like that, you probably got somebody that's not ideal and probably not too connected with their family the way you want it to be.
Right. I mean, if I imagine a familial connection would be a decent factor in figuring this stuff out. So now you got an idea of what your ideal looks like. So give us some of your best elder abuse questions or topics and how you frame them.
Yeah. So my jury selection, I keep it under 60 minutes. I don't, especially if you have the questionnaire. I think you can do good jury selection in less than 60 minutes if you do it right. So the biggest things, and obviously I'll go through all of this at TLU, but there's two things that I think are important. One, what I call the inside the box, outside the box, which is where you're able to frame what the case is actually about and what the case isn't about. You're planting that seed very early on of what are these potential distractions? What are the things I'm not allowed to consider? And it's very simple. It's inside the box, and then everything else is outside the box. What's inside the box? Did they do their job? And did it cause harm? That's it. It's the only thing they can consider. The other thing that I think is so important is getting to these questions of who do you love most in this world, right? And getting that across the board. And what do you love about them? And if they were taken from you, is there anything about the amount of money they make, the houses they own, their income, anything else, would that factor into this at all? And what you're able to do is you're getting, oftentimes it's their parent they love most, their child they love most, whatever. What you're getting them to is you're getting ahead of this idea that economic damages are important, because there aren't any in nursing home cases. You're getting them to the idea that such a thing is abhorrent, right? If they're looking at their parent going, no, it's nothing about money. My parents don't have an income, but they're everything to me. My child doesn't have an income, right? They cost me a ton of money, but, and that's who they are. That's what I love about them. What I would miss about them isn't their future income or anything like that. You're getting them into this mindset of who cares about, economic damages and income or any of these things that the defense loves to use to try to get, the verdict down. And one is getting them in the mindset of that they are appraisers of life. Okay. Appraisers of life. That's it. What is this community value when it comes to brothers, sisters, parents, grandparents, whatever it might be, getting them in that mindset of they're going to be determining that, not necessarily your client, right? But the person in the community. That's what they're doing. They're appraising the value of life. And so that to me is critical. Those are the biggest things to get the jury you want in terms of damages.
And beyond what you're actually doing in the courtroom, are you doing anything, with that jury list of jurors, as far as research about who they are, on social media and stuff before you actually start questioning them?
Yeah. So one is with the social media. What I found most important is who are their pictures on social media, right? Number one, if it's family, you're in good shape, right? If it's their mom, their daughters, all these things, you see some of these that are totally loaded with family. You see other ones, of course, where it's not at all. It's just a rant, right? It's just a person who doesn't get along with anybody, right? Or it's the person who, is always negative about everything and complaining, right? You learn a lot about a person's character just from their posts, just from their Facebook, because you're seeing, one, how they interact with other people, and you're seeing what they value, right? They're putting what they value on there. If it's a person that all their pictures are pictures of them in new clothes, for example, that's a bit of a red flag, right? That takes away from just showing you what they think is important. The other thing to take a step back with jury selection is to start it off with team building, right? It is a team. The jury is going to be a team, and identifying and have people discussing what they're best at and why they're good at it and how that's going to contribute to the team, because you're getting people in the mindset of we're all working together, all of us, including us as lawyers, right? We're all in this together. So planting that seed early on, I think is also very important. I should have mentioned that.
All right. And so after we got our jury selected and we got our ideal group of people to deliver justice, tell us how do we go about getting ready for and delivering that opening statement to drive our case home?
Yeah, so the opening statement to me, obviously, like I said earlier, you've got to have a great story. And you may not love your client, but you better be in love with the story. And that story has to have a breakdown or a violation of a key value that everybody finds important, right? It has to be a common denominator. And there are things that we all think are important. One, keeping your promises, right? And what do we see about nursing homes? Look at their advertising. They make lofty promises. They're going to treat them like family. It's going to be one-on-one care. All these amazing, glowing things, promises they don't keep. Betrayal. There's also huge betrayal because family members are kept in the dark. They're supposed to be given all the information. They're relying on the nursing home, and they're not. So setting that betrayal. And I don't, talk much about the family, and I only talk about my client to the extent that we're talking about the defense and everything bad that happened, and the person it happened to is my client, right? Not how great my client is, how lovely my client is, how the family misses the client, right? It's all of the things the defense did. That systems case is the story. It is the broken promises. It is the lack of fairness. It is the betrayal. And your client's an example of that, right? It's not about your client. It's about the bigger picture. This happened to the client, and it could happen to anybody else. And that's, again, getting to this kind of tentacles of danger, people thinking, yeah, this has to stop.
And do you typically have some type of length that you like to keep your openings, within, or do you just, whatever the case is, some openings are 20 minutes, some openings are an hour and a half?
It's the more I've done this, the shorter they've gotten, because you're identifying what's important and what isn't. And in reality, the only thing that's particularly important is the story and whatever critical facts are necessary for the jury to find in your favor. Not all this fluff that you see. There might be 20, 50 violations of the standard of care, but they didn't do anything, right? And so getting it down to what is the core value that was violated, why was it violated, and the collateral damage, who it was violated, right? Who it resulted in. Because again, I think your client has to be an example of what the wrongdoing does, not basically the protagonist in the story.
All right. And so after you drilled home your opening, now we're ready to talk about, presenting your witnesses. So who is your go-to person typically to come out of the gate with in an elder abuse case?
It has to be former employees. It has to be. Because former employees, I try to hide my client. My client comes late. It has to be former employees, and or it has to be family members of other residents, people that have no stake in the outcome, people that saw firsthand. Former employees are particularly powerful because it puts the defense in a precarious position. One, the employee is potentially lying, but if this employee is willing to come into court, swear under oath, and lie, they've got some explaining to do as to why they worked at this company for 3 years taking care of these elderly people, right? So they're in a bad situation. And I try to stack them early on, right? It's social proof. So one person, maybe I believe him, maybe I don't. Two, a little bit more convincing. 3, 4, 5, 6, well, they can't all be lying. They can't have all concocted this story. And when I have those people on, they're not necessarily talking about my client. If they have information about my client, super. But a lot of times it's talking about, hey, in this wing where I worked or I floated, I'd see this, I'd see this. Call lights were going off. People are screaming. I can't get to them. It was horrible. I walked off the job. We complained to management. Those kind of people are powerful. And they're identifying the violation of this basic human value. Then we might have to get to experts, or we might have to get to family members, but not my client. I want to save my client where when my client is testifying, the jury is already convinced everything was terrible, and they're looking at my client now with empathy. And the reason I find that so important is there's a lot of what if happening in these kinds of cases, and people don't want to imagine themselves in this situation. Jurors want to imagine themselves, I'd have done more. I'd have gotten my mom or dad out of there. I'd have done this. Why didn't they do this? What if this? But when you front load it with the bad story of why it's happening, what's happening day in and day out, everybody in the facility, Now your client is secondary to this, right? Now they're basically, you've insulated them from this negative attribution the jury is likely to have.
So after these ex-employees, you said it may be, you said it may be experts, it may be family members. So tell us, when it would be an expert and when it would be a family member? What would be the circumstance? Because to me, instinctively, I'm going with experts now to get the story up before the family members. But tell me when we would do each one.
I would do a family member at this point only if they have something critical to say about what happened here. So for example, I was at a care planning meeting. They promised this, this, and this. That didn't happen, right? So when it's critical to what the jury needs to find in this case, family member. And then I keep everybody very short. I mean, I try to have lay witnesses to be 10 minutes or less, including family members. I try to keep experts to well under 30 minutes. And two reasons. One, experts are a bit of a wash. We know that, right? Nobody particularly trusts experts. Experts, in my mind, should be providing the basis for why the rule that was violated is so harmful, not telling you why that's the rule, right? They just want to enforce the rule the jury has already determined is important, right? They want to tell you why that is, not what it is necessarily. I try to keep them to 30 minutes or less. And there's a lot of research that, again, I see lawyers put on experts for hours. I see them put on family members for way too long. And one, that's boring. Two, there's a ton of research out there that shows that our memories suck. We think our memories are great. They're terrible. We forget 50% of what we heard by the end of the day. And by the end of the week, we've forgotten 90% of what we heard. And psychology study after study after study shows us this. So you might have thought you put on this awesome stuff on Monday, Tuesday, but by Friday, well, the jury already forgot it. So keep it short.
Experts. So what experts are typically the experts you're retaining in these elder abuse cases, though?
So you have to have somebody who is a director of nursing at a nursing home. Check out where they work, because just because they're an expert doesn't mean the nursing home they run is any good. So that can backfire quickly. But it has to be a director of nursing. There has to be a medical director. So that's the doctor who is a geriatrician, treats older people, and who's in charge of the facility. Then you have to have typically some kind of specialist for the actual issue involved. It's an infection case, you need an infectious disease doctor. If it's a wound case, you need a certified wound physician, obviously. And a lot of times I have a forensic pathologist, and the defense doesn't for some reason. Forensic pathologist is the death doctor, right? They determine causes of death. That's all they do day in and day out. Hopefully, I have the coroner or medical examiner, again, totally impartial, who's testifying in this case, because obviously they're going to carry the day. You also have the potential for treating physicians here at the hospital to show what was actually going on, right? Again, they're going to have tons of credibility. And what I would recommend to people is your doctors later on in the case that see them after the nursing home, they may have a very different picture of what happened than, what was reality. So I'll give you an example. I have a case right now where the hospice doctor certified not only the cause of death, but the reason for going to hospice as dementia, right? She had end-stage dementia. Why did he think that? Well, she had a diagnosis of dementia and she came in all confused, wasn't eating, and all these problems. What he wasn't told is that in the month and a half before that, she had fallen 5 or 6 times, fractured her spine, was consistently going downhill. He didn't have that information. So once I met with him, got him that information, said, look, my cause of death is wrong. My hospice is wrong. And not only is now causation getting better, but he's actually pissed that he wasn't given the right information from the nursing home. Again, betrayal, right? He feels betrayed. The jury understands they're hiding the ball. So I would really recommend that people vet every doctor they can, because there's a really good chance that even if that cause of death looks wrong on the death certificate, it's because they didn't have the information, didn't have the whole picture.
All right. And I know that in your cases in chief, so I want to talk to you about cross-examination, but I know a lot of times you're calling some of the defense witnesses in your case in chief. So let's talk about that for a moment.
So what I like to do is you've got the former employees who tell the real story. They have not been corrupted by the lawyers. Then you likely have the people involved intimately with what happened, the nurse who let him fall, whatever it might have been. Well, their story is going to be very different about the facility. It was well staffed. It was this, it was that. You've got this contrast. You've got this juxtaposition where they're clearly told what to say by the lawyer, right? They're clearly so prepared to say these things that we already know aren't true. We've already decided they're not true. So you're identifying it as a lie without saying it's a lie, right? The jury comes to that conclusion of this is total bullshit, right? So, and everybody knows once you form an opinion yourself, it's almost impossible to break that opinion, right? It's your belief now. And so that to me is critical. So keeping those short, again, keeping them short, 10, 15 minutes, getting out that juxtaposition, as bad as you may think it is as a lawyer, because the records look so bad or whatever it might be, you've already proven in a just general human way what the story actually is from these former employees. So keeping it short, same thing on cross-examination, right? We know that these hired guns who come in, whatever their credentials are, they're willing to say absolute bullshit, right? And so I treat it like bullshit, okay? It may be a cross-examination of some infectious disease doctor from Harvard or wherever. It might be 10 minutes of cross-examination. It might be total garbage. And I'm going to treat it like garbage. I'm not going to be rude, but you're going to identify that, what I do with cross-examination is I'm telling the story again about all the violations of the standard of care, the lack of job performance, I don't care what the expert has to say. Again, you're just telling the story shortly to build it in to the jury's mind.
All right. After we cross those experts, let's talk about how we get ready for closing. For the closing,
Well, let me just say real quick. So a lot of what would be my cross, I do on redirect, okay? Which would be something like you have, let's say they've crossed my doctor, right? I'll ask them, so let's say they have a cross on my doctor, sometimes 4 hours I've seen. I get up with my doctor and the redirect and say, doctor, I timed this, and I've got it written down. For 47 minutes, they asked you questions about X, Y, and Z. Does any of that have anything to do with this case? No, right? Is that just a distraction to the jury? Yes, right? I'm always trying to dispatch of these distractions to make the jury realize that was total bullshit. Why'd you waste my time for an hour on, whatever the hell they're talking about?
Right. So your redirect eviscerates their cross as being irrelevant, to summarize it, because the stuff that they want to hone in on has nothing to do with what happened in this case.
Yeah, which is, again, you have to be very confident in your case. You have to have edited your case down to the core things, because we've all seen lawyers chase down on redirect all those things that came up. Same thing in cross-examining the defense expert. They're chasing down these defenses and they're talking about things that are irrelevant, but the jury hears over and over about these things. They become relevant. You made them relevant by talking about them so much. So the less you can do that, the better case you have.
All right. So let's talk about the closing and damages. How do you get these, honestly, these somewhat repeatedly outlier verdicts on behalf of these people that are so close to death's door anyways, and to get people fired up about them, to come up with some of these numbers on the, because we've done 2 case analysis with, 3? See,
3
with you? Oh, you see that? Because those are all on, just so you know, those are all on TLU on demand, and for each case analysis, they're roughly 3 hours. They go through the entire trial from focus groups to, rebuttal argument, and sometimes beyond that, even to collection. But, and we go over it in detail. And I also ask not only Michael, but all presenters to give me the pleadings, PowerPoints, and transcripts for every trial. So it kind of becomes a library of trial. And I know that you're going to be hosting 4 webinars in the next month or so. So tell us about when those webinars are, who are the trial lawyers that you're hosting, and they're all elder abuse cases, and give us a little snapshot of each one so we can all plan accordingly.
Yeah, so May 10th, it's a webinar. Pat Murphy is the lawyer from up in Cleveland, my neck of the woods. He got about a $3 million verdict in a case that, person was very, very ill. And, it was a failure to clear out the mucus basically in their mouth, and they choked to death. And they got some great visuals in there. Really a tremendous result that he got under the circumstances. That's May 10th. May 15th is actually two of my former colleagues at my first law firm, Dustin Herman.
Oh, you got Dustin Herman coming on? I love Dustin.
I do.
He's
fantastic.
I know him through John Romano. He's such a nice guy. He's a great guy.
He is. So at my first firm, Spangenberg, Shibley, and Leiber, he came up directly from Romano's firm. That's where he still is. And he's just a great guy, and I'm really happy for him that he got this verdict. Just last week, he got the verdict. $6 million case, $6 million verdict in Akron, Ohio, just south of Cleveland. And that's a failure to follow up on an infection case. Typical run-of-the-mill nursing home case we see day in and day out. And they were able to get $6 million on that verdict. That's May 15th. May 17th is Sherrod Millenfar, and he had a $31 million verdict in California on a case that I think 99% of people probably would have passed on the case. So I think it's going to be fantastic. It's an elderly person. There was certainly some bad care. She was transferred to some places she shouldn't have been. She fell and broke her humerus, her shoulder basically, but then died like a year later. And it was a $31 million verdict. So we're going to find out what they did to get that. It's awesome. And then on May 31st, Keith Mitnick, he got a 8-figure verdict, $12 million verdict down in Florida. It was a bed sore case, non-death case. And what I think is great about that case is he developed some fantastic rules and really some fantastic mnemonic devices. It's a pressure sore on the person's back. And part of the theme of the case was the nursing home had her back, right? They had her back, right? So he was working that in. The other thing, and Keith's great with language, obviously, is it wasn't a DIY, right? Her turning and repositioning to prevent a bed sore, it wasn't a DIY. It wasn't a do-it-yourself. And so everybody got that, like, oh, DIY, like home care. They all get it, right? Taking care of, building something. Needed help, right? She needed help to do it. It wasn't a DIY, and they had her back, and they didn't, right? And she got a big bed sore on her back. So that's going to be, I think, very powerful. That's May 31st. And
Spencer Payne will be on that one too, because he co-tried it with Keith. And Spencer also is going to be out in Huntington Beach with us. So it's going to be fantastic. So I'm looking forward to...
Huntington Beach is going to be phenomenal. I mean, the lineup is beyond belief.
Oh, it's going to be, besides the lineup, the fact that we bought out the entire hotel, we got, honestly, like the great 4 lecture tracks, 8 workshop tracks. Like your master class, there's going to be actually 7 different 2-day master classes that people can learn about. Med mal from Lloyd Bell, premises and negligent security from Ben Cloward, fucking bright my place. Sean Claggett Sykes is doing a 3-day trial college with how they build cases from intake to collecting on the money. One of the main tracks. Besides, Panish and Freed and that, Paris. Just on and Satchel. The list goes on and on and on. Steve DeBosier from Louisiana. So it's going to be. I'm really psyched about it because not just great education, but like it's gonna be so much fun because every night we have a theme party and we have food trucks every night. And like I said, we bought out the entire hotel, so we have a DJ in the lobby every night with a couple ping pong tables and maybe a foosball. That's my vision. Might get changed there, but got the presidential suite all 5 nights, so it'll be like a really cool after hours going on. It's just, I can't wait because I've been working at this for a while and I take a lot of pride in my ability to organize these events and make them like, honestly be like 10s on education. Because that's what people are coming for, education. And when people are learning stuff that they can visualize how it's going to transform their cases, transform their financial situation, and, transform their life, they get excited. And then besides that, all the people you meet, like you're going to meet so many people because of the workshops and having everybody do a personal bio, telling their story in the first person about who they are before they get there. And like the theme parties, Thursday nights theme parties, a Ken and Barbie pink and white party. Friday night's a Wild West theme. And then Saturday night and Friday Wild West theme, we also going to have live band karaoke. And Saturday night, a Vegas theme party. So it's going to be awesome. I just can't wait for it all. But it's about 45 days away, so I got to work really hard until then, which means concluding our podcast here too.
And let me say, not to make your head too big here, but just to hype up your boot camps a little bit. My associate was out there, very little experience. He'd done some stuff before. I'd watched him in terms of trial presentation and everything else, and he certainly struggled. And then we were back at my house preparing for trial, I don't know, a month after he was with you. And I literally thought to myself, who is this guy? This is a totally different person, totally changed person in terms of the way he was communicating, even the timbre of his voice, the way he moved. And I just thought, man, this is a different person altogether. So I don't want to hype you up too much. I don't want to get your head and ego too big. But it was like a different person. It was phenomenal.
I appreciate you saying that, because June 2nd through 4th, which is the 3 days before the actual conference starts at June 5th, I'm doing a 3-day boot camp for 8 people, and to learn all these skills, these micro skills of presentation that are mostly unconscious that people never think about, like their eye contact, the pace and the cadence of their voice, their facial expression / emotional state. Like, what is their face saying? Is their face saying, welcome everybody, I'm confident about this, or God, I can't believe we're here, I'm scared shitless? Because your face is always telling a story. Whether you're aware of it or not, it's telling a story. And just like your hand movements, people's use of their hands, like, when they got 2 hands by their sides, like most people do, and they're bouncing them up and down. Like, the only time when people's hands move like this is when they're really upset. It's like, what the hell are you doing? And their hands shake like this. Instead of, typically, using one hand between themselves and the person connecting with it, about 6 inches below their chin. So all these skills make all the difference in the world. And, and we're going to be running these if people don't, for one reason, don't want to or can't do the 3-day boot camp, they can do condensed versions in a half a day or 1 day during the conference itself. So they're on their feet practicing their skills, like the presentation skills. In the morning, they'll be working on learning those skills. Actually, the 3 Zoom meetups before the conference, they'll be working on, learning those skills. In the morning, kind of refining those skills. But in the afternoon, to be applying their new skills of presentation and connection to their actual trials that they got coming up, so they can see the application, experience the application of what it's like to be a much better presenter. So I'm super fired up about that, because those 8 people are going to have the most transformative experience of anybody that's ever been to a trial college. And I've been down to plenty of trial colleges. Went to the NCDC trial college back in 1996 when I was a criminal defense guy. Spent 12 years at the trial lawyers college. And, that was 3 weeks at a time. And let me tell you, 3 weeks is a long time to be away. And, frankly, there's a lot of those places have a lot of stuff that they do that really doesn't have a lot to do with being a trial lawyer. A lot to do with being a better person, but not the trial lawyer. Where these 7 days are going to be focused just on becoming the most badass freaking trial lawyer that you can become, because that's what it's all about. Great if everybody else can do it, but if I can't do it, it ain't helping me much. So, but let's talk about closing argument and getting that money for these people and their families, especially how you go about it. I know that, so many of these cases, the family members are not that connected to these people, especially if they got dementia. How often are you going to go visit a person with dementia who is drooling out the side of their mouth and doesn't know who you are? Really?
Yeah, no, I've had 8-figure verdicts in cases where, maybe one family member is there 2 times a year and 3 family members haven't seen him in 4 or 5 years. And here's how I think that happens, is that keeping in your mind that theme, it's bigger than this case. It's bigger than us. There's a greater problem beyond what happened here that the jury has to solve. And you're setting that up in jury selection. You're doing it in an opening statement. My slides and closing argument very much track what I said I was going to prove in opening statement, because that's credibility, right? And you have to identify, I think, again, the jury being appraisers of life and appraisers of everything. So what's the value of life in this community? There's going to be a record of it. They're going to write it down, and it's going to be in the courthouse. And any single person that goes there and views that is going to identify, and they're going to know how this community values the life of a brother, a father, whoever. That's powerful. You have to have a verdict that values truth. You're going to have all these falsities, right? When I say a verdict that values truth, I'm priming them that there is not just who won and who proved the case, but that we value truth, and there should be a large verdict for people that come in and lie to us, that try to fool us. And then very importantly is identifying the power, giving the jury that knowledge of the power that they have. And there is a ton of stuff that judges do when they're introducing the case that you can take note of, write down verbatim what the judge said. And a lot of times it'll be things like, this is the most important part of our government. This is the oldest, purest form of government there is. You are the government during this trial. And what you're doing them is, and I specifically say it, you have the power in this case that you'll never have again, that few of us ever have. You have the power, and you're not quite getting into punitive damages because you're not allowed to in a lot of states at this point, but you're giving them that knowledge that this is you've already set it up, it's a bigger than us, and it's not about this case. So they're not providing money damages necessarily for, a 91-year-old person with dementia who fell down. Yes, that's the example of what happened here. But you've primed them and you've armed them to now do something, to feel important, right? To make a change that they know is going to benefit their community and society at large. So I think doing that is beyond important. And again, you're taking, to some extent, the specifics, not the specifics of what happened. That's obviously very important. But you're taking now the specifics of what happened as an example of the larger problem that's happening here. Again, this is your theme throughout the case. The other thing that I do that's very important in jury selection, and then it builds into the close, is this inside the box and outside the box. And they're only allowed to consider the actual things they heard about the only thing that's important. Did they do their job, right? And did them not doing their job cause harm? That's it. That's the only thing they're allowed to consider. And so when you're doing this inside the box, you can really dispose of so many things that you heard throughout the trial. So it's, you're arming the jurors. So if when you get back there and somebody, is saying X, Y, and Z, somebody's saying, well, that's more money than I make in my lifetime, or that's more this, or this other thing. What are they going to do with the money? You're doing the inside the box, outside the box, and you're framed at the whole case that you can't consider that, right? And so if anybody back there says that thing, bring them back to what's in the box, which is all you can consider. So you're framing that throughout. But I think the biggest, most important thing here is communicating that it's bigger than all of us.
When do you start thinking about your closing argument in any particular case?
I start thinking about my closing argument basically from the day I have the case, right? Because my closing argument is going to mirror my opening statement, right? So I have to find the story. So part of look, I think all of us have had clients that we don't like, okay? That I don't know about this client, but you fall in love with the story, right? And so that's part of the vetting process, is spending time with my clients, going to their house, eating dinner with them. I've eaten more terrible dinners at clients' tables than I can even imagine, right? But you're falling in love with the story, right? Even though I can't really identify a lot of times with the specifics of the story in my own life, there's parts of the story that are these universal values, these universal truths that I can imagine myself being in if they were violated. So, that's critical. I think to love the story, know the story, and find the value that was broken in the story.
Michael, these cases with all these experts and strategic and things you got to find, what's the average cost of litigation for a case you're going to trial on?
So by the time
range.
Trial is done, you're looking at, I think on average, $150,000 to $250,000 in expenses.
And with the number of cases and expenses, do you cover all that stuff, or do you use litigation finance?
So I use priority litigation funding. And I met Brett, I don't know, maybe 4 or 5 years ago, had a Zoom call with him, and just found out how easy this was in terms of having the money to do the case the right way. I mean, you take 3, 4, 5, 6, 7 of these cases, and I've got 40 of them. You start multiplying by those, and what I think it forces people to do is settle their cases because they're afraid that they might lose the case. Having priority, really having your back in that situation, putting up the money with you and the ease with which you get it, it gives you the confidence to go to trial and not worry about what if I lose this case, what if. That shit's in the back of people's mind all the time. And what do? They settle it, right? They end up settling the case because they're terrified, right? This gives you that confidence of, you know what, I'm going to tell the story and whatever happens, happens.
Right. Oh, I forgot to also ask, another thing, and that is, if people want to get a hold of you, Michael, how do they find you?
So the easiest way to find me, my website is protectseniors.com. My email is michael.hill@protectseniors.com, or just call my cell phone or text me, 330-785-6968.
All right. And if people need to get a hold of me for any reason, you got any questions about boot camps, anything like that, or on demand, or coaching, my phone number is 248-808-3130. And my email, of course, is dan@triallawyersuniversity.com. And if you can't make it to Huntington Beach for whatever crazy reason, we're going to be in Las Vegas, October 16th through 19th at Caesar's Palace. And that's going to be a really big to-do. And the first day of that conference, October 16th, Sean Clagg is going to be hosting a golf outing at Valley High, which is a very nice place, and for 144 of his closest friends. And if you're not interested in golf, Nick Rowley and Courtney Rowley are going to take out a group of folks out to Red Rock Canyons to do a little yoga, meditation, and hiking. So those are some pre-conference things besides the list of superstars and great time Vegas is going to be. So that covers pretty much what I wanted to cover here today with you, Michael. Although September, different than Huntington Beach, which is going to be June 5th and 6th, you and I are going to get together here in Vegas we call this that's the Vegas Dojo here. It's actually going to be a little bit bigger by the time you get here in September, because the other side is going to be part of the dojo too. I mean, the condo next door to me is in the process of being remodeled, so we're going to have the greatest training facility ever fathomed, at least by me. May not the whole world, but at least by me, with a great view of the Strip. But anyways, so we're going to do that.
Let me just say, here's my goal, and this is how I set up this masterclass. My goal is that, look, I specialize in this. It's all I do. I have the benefit of that. Most people don't. But a lot of PI lawyers, they have these cases come in the door, and they don't know how to work it up. And I think in these 2 days, simplifying it, just following this script, you'll get the case. And you can get big money from the case. It's no longer one of these, let me settle it for $400,000, $500,000, $600,000 cases. It's let me go to trial and get a big verdict kind of case for kind of the everyday PI lawyer.
Right. And during these 2 days, though, we're going to be framing and talking about it and seeing examples from your case. But people are not going to be, at least in this class, are not going to be getting up on their feet and practicing pieces of their own case. But I know that on the 7th, you're going to do a half a day workshop for folks, like for 5 people, maybe 6 people who have cases that they're working at putting together. You're going to help them a little bit pre-conference to get the story, and then you're going to work with them and not just getting the story, but also getting on their feet and presenting different parts of it with one of myself or one of my other instructors here for my boot camp, so they can get the on their feet and put the physical parts into practice too. So that's also going to be available in Huntington Beach. But beyond that, in Vegas, we're going to do something similar where we have 8 students who have elder abuse cases who you've worked with a little bit beforehand on this framing that you're talking about. So now they know what story they want to tell. But we just finished a boot camp this weekend, and Bobby Tagabi was here from Sweet James Injury. He's like the managing litigation partner for Sweet James out in California. They're in Vegas and Arizona. But as we were practicing different parts of people's openings, he's like, boy, I just never really realized everybody works so hard putting the evidence together, putting together their visuals. But most people, the last thing they start thinking about is getting up and actually presenting, actually telling the story of what happened. And, he was like, that was just so valuable, like to start doing that, because that's the part that matters when the rubber meets the road. And so that's what we're going to be doing here in, Las Vegas that weekend is, you're going to be finding the story, continue to find the story, because also a fact of reality is that when you're up telling your story of your opening and you're emotionally congruent with the characters, with the story, you keep reliving that story. It becomes more vivid and real to you. So now you just feel more confident, comfortable believing in the story that you're about to tell, instead of like, well, I'm not sure the word, the tentativeness that comes from a lack of preparation, or the tentativeness that comes from the lack of comfort level. Even though you got a great story, if you're not comfortable telling it, it don't sound nearly as compelling and persuasive. It's just the reality of it. So I'm looking forward to that too, because We're going to have lots of new verdicts to talk about by then from yourself and Joe McCoy and Matt from that we're going to be working on. So this is going to be great, Michael. I'm fired up. I'm fired up about this whole elder abuse thing. And I talked about people like, oh, those are garbage cases. Oh, this. I'm like, maybe the way you're looking, maybe the ones you're looking, or the way not the case you're looking at, but the way you see it is you don't see the value, but it's like, you can start seeing the value. I can start to see the value. So even though I was never enthused about this, I am now. So that's all we got. So thanks for visiting, Michael. I look forward to seeing you maybe as soon as next week, because today is April 22nd, the recording date. But, in about 2 weeks, we might be getting together. No, but we're going to get together maybe before that in Ohio for a couple of focus groups.
Oh, that's right. You're coming out for my focus groups and mock trials. That's exactly right.
What good is it to do these things without a coach nearby? I mean, it's good, but it's not nearly as good. Anyways. All right, Mr. Hill, great seeing you. Great visiting with you. Great, learning about not just what you're going to do, but just learning more about how to put these elder abuse cases together, whether you make it to Huntington Beach or not. If you got an elder abuse case, you still got to get better at it for the sake of the old people. We're all going to be there one day. All right. Thank you. Take care. Goodbye, everybody.
Thank you, Dan.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.